Hello? Hello? Did we lose audio? Can you hear me? Can someone just type in where we lost audio? I was just basically reviewing the objectives of the slide deck. Thank you so much, Mary, for mentioning that we had some audio dilemma. I can now hear you. Perfect. So just really quickly, these are the bullets and the objectives of what it is we're sharing. I'm not going to go back and read them all. I just basically said that I have a dynamic, interactive approach. And, oh, I never heard anything you said from the start. Okay. So here's what we'll do then. I apologize. We'll just go quickly back here. All I said was my name is Shay. Shaweta Vasudeva is my whole name, but please refer to me as Shay. This is going to be Documents for Life, Getting Your Affairs in Order. And then please, can you put a Y if you all can hear me now, so we'll do it that way. And basically all I said for my introduction is that I've been in the field and working in psychology and the field of helping people in sensitive issues such as getting your affairs in order since 2001. And so I really would encourage you to sort of use me as a resource. So, okay, yes, by computer, perfect, that works. I do apologize for that. But the good news is all I literally went over was the objectives, so we didn't miss much. And here they are, and all I basically said is that I'm very interactive, and I want to make this your time and the most out of your time. So if there's questions at any time, feel free to ask and to put them in the chat, right? And if you have not muted yourself, now is a great time to mute yourself so we don't get that background static. So these are some of the objectives. I literally will not read them again, but you have them up here, and we'll just cover each of them. The one thing I do want to say is, how has the need for documentation changed over time? I won't spend a lot of time over that simply because I feel like all have this realization of how technology has changed and the market has become globalized. And so more and more the documentation is needed, probably younger and younger, and more being just proactive. And I mean, the good news is because of technology and apps and things like Legal Shield, which we will get into, we're able to access this documentation pretty readily, right? So we'll discuss the rest of these things: who, what, where, when, how should they be retained, and how do you terminate or extinguish them. So without further ado, we will get right into this. So now, I already touched on this a little bit, the impact of modern society on our lives. So we have so many more choices these days about our lives, and there are many options to be able to take care of these paperwork. You know, it used to be you would call into an attorney or go into a location, fill out some paperwork, and now you're actually able to download some apps, work with attorneys remotely and things like that. You know, what I would recommend too is also to check out your specific state laws and your specific county laws. There are certain ones that are national, and there are certain ones that are specific to you, and we'll break down in a minute here in a couple of slides the different documents, and I have some websites that you all can go to out in your location. So we will talk about medical advances and also marriage and remarriage. That's becoming very much a cultural norm. You know, many people are having multiple marriages, and some are choosing to not marry at all. We also have the same-sex or transgendered marriages in the states that are where it's legal, and then end-of-life choices and passage of property. So times have certainly changed. So here we have types of documents, which we will be reviewing. We'll discuss Social Security, advanced directives, where to get them, again, how to get them, when it's appropriate to get them, when it's appropriate to change them, who to go see. And then, of course, the Affordable Care Act has changed some things as well. And the wills, beneficiary forms, trusts, guardianships, and conservatorships. So very important things as we progress in our lifespan here on Earth, right, as we age. So the first one is your Social Security card. In general, it is applied for at birth. And now, it's not intended to be used as something to identify you, right? So that would be more of like a passport or a government-issued ID, such as a driver's license. Now, it has become a key primary identifier for medical matters. When you go in to purchase life insurance, when you go in to purchase a policy, when you go into the hospital, one of the top things they will ask you is your Social Security number, but it's very rare that they actually ask for a copy of it unless you're in employment, and so that would be one form. But even with employment, you know, you would get your sheet of your approved identifications. But since the Social Security card does not have a photo on it, it is typically not used as an identification. So this number is very important to protect because it is widely used by financial identity thieves. So if Plow and Hearth offers identity protection, that is one way to protect your Social Security number. The other one is, I'll get right into it, are certain apps. You have Legal Shield, and then you also have, well, let me talk about Legal Shield really quickly. And what they do is they're an app that you can purchase for a monthly fee, and they have different tiers of membership. Now, they also have identity theft protection with that, as well as an additional sort of coverage for you. And then you can also get the coverage from your banks and such as well, or your financial institutions will sometimes also offer these things for you, and that you can purchase them through the accounts that you open. And then also is you only receive one in your life, and it provides assistance after you reach full retirement age. And for this one, to do the prevention of identity theft, always bear in mind to consider the source of who is asking you for that number. So again, that's your Social Security information. Now we have next is advanced directives, and these are all of the types that you have here. You have your living will, which very much self-explanatory, is the will that you have while you're living, while you're alive. And then you have what's called a medical proxy, a power of attorney. Now, where do you find them? I did a little research here for you all. One of the things you can do is you can either look up your state bar, and you'll be able to do it that way. You can also contact your attorney or an attorney. So with the EAP, you can contact the phone number, which will be provided at the end of the slide deck, and you can discuss that you would like to set up a living will and do some advanced directives, and they will then refer you out to an attorney or to the local organization which your company works with. The other one is if you are getting to be of retirement age and you are starting to be contacted by the AARP, that is another wonderful resource. And so they actually will, if you go to the AARP website, they have here family caregiving, financial and legal advanced directive form. And so they have downloads that you can get here, and it says choosing a state. And I see Arizona, which is where I'm out of, and I believe you are all out of Virginia. And they have an option here for Virginia as well. So multiple ways you can get them is through your EAP, ask for that legal referral, through an app if you're into doing that, through your attorney if you have an attorney, and then you can also Google or look up your state bar, and they will have resources for you as well. And the cost will vary, of course. The more you do sort of on your own and in the preparation of them, then the less the fees. But if you want to work with someone right up front and have a legal entity prepare that for you, obviously there will more than likely be fees, the preparation fees and so on and so forth. Now here we have is a will. Now who should create this will? And that should be by a lawyer. Now I'm sure you work with a lawyer, and Usually what ends up happening is sometimes they want a retainer or sometimes they have a flat rate fee, and that would be something to discuss and ask that lawyer or that attorney that you're going to work with. And my suggestion is to go in prepared, right? Almost like when you go in to do your taxes and to see your accountant. And so, you know, be prepared with what it is you want in your will and have an idea of who you want to bequeath that to upon, you know, exiting this life. And so, you know, you may not have the very much of the specific details, but, you know, we want to do a little bit of preparation here. And usually when you call the office of the attorney, they will certainly provide you details and steps to take. Would you recommend using online services like LegalZoom? So I discussed Legal Shield and I discussed LegalZoom. They are both viable options. I would encourage you to do your research. I've had mixed reviews on both. And what I would say is every person sort of has their own style. I've worked with individuals that have tremendous success and respect for LegalZoom, and I have others that really like that in-person sort of situation. Same goes with Legal Shield. So they are options on the table, and I would see and do some of your independent research on them and also think about your style. Do you prefer sort of an in-person meetings, or are you okay with the technology and doing some of these things remotely, right? And then, of course, with LegalZoom and Legal Shield, you start remotely, and then eventually they will put you in touch with a law firm that's contracted with them. That's the other thing to consider is when you reach out to Legal Shield and you reach out to LegalZoom and you get those apps, you are basically, they have local firms that they work with, correct? And so those are the firms that you will end up working with. Now, if you want a much wider scope or a much wider choice and you want to be more selective, then I would suggest that you then do your own research. However, if you're just, you know what, I want to get these forms done and I trust the app and I trust the firm that they're choosing and the company, and this is how I'm going to do it, and I'm going to streamline things. So just basically I always talk about what is your style, what resonates with you, and to try these things out as well for you, right? So hopefully that answers your question. Very good question on Legal Shield and LegalZoom. So the other thing you could do, so if you're an apps person, you can do Legal Shield or LegalZoom. Another one is that I looked up here. It's called 5 Wishes. So 5 Wishes is a United States advanced directive, and it was created by a nonprofit organization called Aging with Dignity. So basically, the quotation here is, some people describe it as a living will with a heart and soul because there's 5 pieces to it. And so basically it was introduced in '96, and it was introduced as only for Florida, but then the American Bar Association really thought it would be beneficial, and certain foundations stepped in, and now it's offered to all 50 states. So that's good too, especially because if you end up relocating, hopefully that does not happen, but sometimes it does. And so basically, in the 5 wishes, wishes 1 and 2 are considered legal documents, and wishes 3, 4, and 5 are more quality of life. So wish 1 would be the person I want to make care decisions for me when I'm not able to, right? The person I want to make care decisions for me when I can't. Wish 2 is the kind of medical treatment I want or do not want. So this part is sort of a living will. And then how comfortable do I want to be? So now this is wish 3, wish 4, and wish 5 are more quality of life. How I want people to treat me and what I want my loved ones to know. So if you do this, this is more of an independent thing where you would do your due diligence and answer this. And then what you do is you contact your state bar association or your state Secretary of State office. And you would register these wishes with the state so that when you went to the hospital, they could pull it up. And it's in their registry. And you would say, you know, I have these advanced directives, I use the 5 wishes, and the forms are in your system. So I want to really impress upon you, if you do your own preparations and you do something like 5 wishes, or some of your own documentations where you download them and do them, you know, you will need to register them with the state. And sometimes here it says will, this document should be created. Well, I'm sorry, I don't want to confuse you. This slide is your will, and with the 5 wishes, the first piece is the will, and I kind of jumped ahead a little bit. The second piece is your living will. So you certainly want to register it. So with the state and with the bar, and reach out with those proper authorities. So if I confused anyone here, let me know. I hope I did not. So we have our will. Documents should be created or written by a lawyer, and then I jumped ahead a little bit with the living will, and then obviously registering that with your Secretary of State and with your governments there, so that when you go to a hospital or when you're in a precarious situation in a professional aptitude, do you have advance directives? You say yes, they must be registered. You can't just have it in your home and say, oh, you know, it's written down, it needs to be formalized and put in the registry. So that's a very important piece. And each state sort of differs, and I did look up some with Virginia, and Virginia is a state that does do the 5 wishes. There's only a few states that don't currently, and there's 8 states that don't, and that's Alabama, Indiana, Kansas, New Hampshire, Ohio, Oregon, Texas, and Utah. And they need a statutory form witnessed by an attorney and notarized. So again, some of these are going to be state specific. Will is going to tell the court how you want your property divided among the people that survive you. So moving on to the next slide, here's more of the will. So someone here asked about cost. The cost is directly dependent upon complexity and the hourly rate of the attorney. Again, think about when you go and do your taxes, you know, the more organized, the more prepared, the more proactive we are, the less space time we have with that CPA or with our tax preparer, and we're able to, you know, minimize the sort of cost of the preparation. Now, if you're someone that needs more preparation and needs more guidance, and you're in the position to pay a little bit more, then of course that happens. And then also it should be re-signed if you change the state where you live. So again, if you move, you also always want to contact that state bar, that state Secretary of State, and then find out if they have a registry and re-sign your documentation. It should be rewritten with each significant change in your life. So we talked about when is it appropriate for these things to be changed. So if there's a birth of a child, if there's a divorce, if a remarriage occurs, or if there's a death of an heir, these are opportunities where you would need to rewrite your will here. And then the new will invalidate an older version of the will, all wills that have been written before it. That's another important key component there. So next we have beneficiary forms. So a beneficiary is simply the individual who will receive the payout or the disbursement of these documents, of these products that are on this slide, right? So life insurance, pension, IRA, deferred compensation. So here's the definition here. It tells the company who should receive that money or your property attached to it when you pass on. So with these products, many times you are able to decide percentages, right? And so that is also a good thing to think about. Is, you know, how much percentage you want to give to whom. And also one of the other things is to have the conversation with that beneficiary of what it is you would like for them to do with it. You know, if you want to, you know, let's say you have a spouse and you have some children and you want to leave part of your product funds to your spouse to take care of your last right and will and your burial or your cremation. and that sort of thing, then you can sort of allocate a set amount for your spouse. And then if you plan your pension or life insurance or some sort of other products or deferred compensation for possibly children, hopefully this never happens, but should you become deceased, before your children go off to college or have some life milestones, you could make one of them, if they're of age, a beneficiary so they have those funds moving forward. So these are all sensitive things, so I'm carrying it with sensitivity here, but I do want to present these things for you to consider and think about. And then, of course, should your children be of adult, mature age, or you have that relationship with loved ones who you want to bequeath, or, say, I would like you to receive this money upon my passing, and to sit down and have that conversation. It's not an easy one, but it's sort of it tends to be a relief, and to have these things out in the open and save lots of sort of tensions possibly, right? So here we go. Next we have is trust. Now there's two types of trust. We have revocable trust and we have irrevocable trust. And then we have what's called a testamentary trustee, and then taxes. So we're going to go back to this trust. So let me just take a look here. I have, because the slide deck sometimes could be a little lean, so we have a little bit of a leaner slide, and that's totally okay. So you've got the trusts that are revocable, and then you have the trusts that are irrevocable, right? And so that would be up to you and what you would set up with what's called a fiduciary or a third party. Now this could be a bank or an institution. And you also can have what's called a testamentary trust. And sometimes this is also referred to as a will trust or a trust under will. And basically you have a component which is called the testator, which is going to be specified in the will. This will may have more than one testamentary trust, and it may address all of the estate or just a portion of the estate. So similarly to your monies here, where you can have more than one beneficiary in these trusts, it's you have some power. And so one of the things I want to talk about is just always being sort of proactive and setting these things up. So now you have also testamentary trust, and then you also have inter vivo trust. Now, inter vivo trusts are going to be created during the settler's lifetime. So in a testamentary trust, there are 4 parties that are involved. So you have your person, like the individual who specifies that a trust is going to be created, right? The person who's initiating that trust, essentially. And it's usually part of the will, and sometimes so it's usually part of the will, right? And so then that person who initiates or sets up the trust may be called what's referred to as a grantor or a trustor, or they may be called a settler. So again, this is one of those things where you work with an attorney or you work with a fiduciary, an organization, a third party whom you trust to set this up for you. And these are the various different things that you may be referred to as the grantor, trustor, or settler. Now, the other part of a testamentary trust is the trustee. Now, the trustee's job is to essentially carry out the terms of the will. So they may be actually named in the will by you or by your work with you and your fiduciary parties, or they may be appointed by the probate court that is going to handle the will. So here I want to just say, think about your style and how thorough you would like to be. I've worked with some folks who are very specific right down to their silverware. And again, this is a sensitive subject, but it's one of those things we discuss. And then some people really want to leave it open. And the more things that we leave to open, once we pass, I say this again with all due respect of livelihood, we aren't there to clarify, and we aren't there to mitigate, no, this is what I meant, no, this is what I meant, et cetera, et cetera. So I've also had folks who have had multiple pieces of property, and, you know, they've broken it down to where one individual gets a house, another individual gets a house. This one set of people I work with, they own 3 houses, but they had 2 people they wanted to leave these houses to. So then became a dilemma. They sat down, they discussed, okay, person A gets house 1, person B gets house 2, but what happens with house 3? And they left some gray areas there. And, you know, we discussed any sort of gray area, please keep in mind that you're not there to discuss any questions further, that, you know, either a court is going to step in or the trustee, the person that you delegate to carry out the terms of the will, is going to carry it out. So the more specific, detailed, and thorough that you can be with the trustee, that would be extremely, extremely beneficial. So again, keep in mind that when this becomes delegated or gets carried out, that physically you're not going to be able to be there to answer any questions or clarify. So the next piece we have here is the beneficiaries who are going to receive the benefits of the trust. So that's the third part of a testamentary trust. Now we also have the probate court is a piece of the component of the trust activities, and it can oversee the trustee's handling of it. So a testamentary trust is going to be a legal arrangement, and it's created in a person's will. It's very specific, and here I'm using the exact words, is occasioned by the death of that person. And so basically it's utilized to create and address any estate that is accumulated during the person's lifetime or generated as a result of a post-mortem lawsuit, such as a settlement and a survival claim, or the proceeds from a life insurance policy held on a settler. And so a trust can be created to oversee these assets, and a trustee is appointed to direct it until a set time when the trust expires. So that is a lot of details here about your trust, your trustees, and that sort of thing. There may, you know, taxes I don't necessarily want to get into here. They vary state by state, and that will be discussed and carried out at the time of when it is carried out. And they also vary about, you know, the type of property, how much property, and then, of course, the portion of the property that you receive, and then also, of course, taxes and change. You know, going back to that very first slide, times are changing. So just know that there may be taxes involved, and again, you know, it depends on the type of property, how much property, the state, you know, where that property is located, and so on and so forth. So that's your trust. So next we have here is your guardianship. And another great resource for guardianship is your state bar or your attorney or the EAP, right? You can get what's called a legal referral. Now the EAP is a complimentary service for you as employees of Plow and Hearth. And so what you can do is you can contact the EAP for the referral, and then of course whoever they refer you to, that individual or that institution will have their own fees that you're responsible for. So if you don't know where to start, a great place would be to contact that EAP for the referral, Anthem Blue Cross Blue Shield EAP. And then of course you can also, if you have your own attorney, that's a great way to ask. Again, if you're more independent, another great way to do it is looking online and going to something like a LegalZoom or a Legal Shield, and that, so on and so forth. So basically, we're going to discuss what is a guardianship, and usually I am less of a reader, but I'm looking at my notes and I'm being precise with my words, because these things are matters of the law and legal sort of documents, and there's some things that are gray and there's some things that are black and white, and these things are black and white, so we need to be exceptionally detail-oriented as well as thorough. So what a guardianship is going to be is it's an appointment by a court of an individual or entity to provide care and to make personal decisions for a minor or incapacitated adult. So that leads me to the next question of who needs a guardianship, either a minor or an incapacitated adult. Well, then for me, it's, okay, well, or for you, you might be thinking, what is an incapacitated adult? So an incapacitated adult is someone who cannot communicate or make reasonable decisions for themselves to protect their own welfare due to some mental or physical condition. And then, you know, we have a minor, and that's a separate definition. So just to recap, basically a guardianship is a situation where you have a court-appointed individual or entity, and what the guardian does is it provides, he or she or that entity provides care to make personal decisions for a minor or incapacitated adult. So now minor obviously would be anyone under 18, right? And then that minor, the legal term for that is ward, right? So if you're a guardian, you have guardianship over someone, the legal term is ward. Now if that minor has become sort of orphaned or whatnot, or they're in a situation where a guardian needs to step in because mom and dad aren't able to provide, you know, all the different scenarios. I don't want to get into all the different scenarios that could happen with this situation. The point is if you have a minor who is needing a guardian, then you would need to take legal action. I would highly suggest you see an attorney, and you will be filling out forms and taking care of some documentation and going before a court and having a formal procedure to obtain that permission of guardianship. The other one with minors is if you have a minor who has an illness, right, some sort of a mental illness or a physical condition, and you have chosen a trusted entity or institution where, you know, it's relevant to have this child stay in that institution's place, and so you have entrusted that institution to become the primary guardian. Again, very delicate, sensitive topic, and what you would do then is do it with an attorney who specializes in that, and again, I would encourage you to contact the EAP for the referral of that if that is something that is going on. And then also, as a side note, the EAP also offers the emotional support around that. I know this is not necessarily more of an emotional component, but coming from psychology and my psychology background, that there is emotional support for matters such as these. So you can also reach out to the EAP for referrals to counseling and some sessions as well as that. And then we move to, you know, so who needs guardianship? We discussed the minors, children under the age of 18, children with special needs, adults with special needs, and adults financially dependent upon you. So again, we talk about here with the adults, and this is coming from an actual bar association. The specific wording of it is going to be an incapacitated adult is someone who is unable to communicate reasonable decisions for themselves in order to protect their own welfare due to some mental or physical condition. And so how do you choose a guardian? I then went and, you know, looked up some research here from the lawyers and the attorneys at the bar. Who may serve as a guardian? It could be an entity, like I said, an institution or private fiduciary. And a fiduciary is going to be a person or entity holding a license. So when you're choosing a guardian, if you're going with a fiduciary or an entity, you want to ask for their license and do research on this entity, right? And so they have a fiduciary is a person or entity holding a license to act as a guardian for someone who is paid to do so. And this is for either a minor or what they say is an incapacitated adult. In addition, the court can appoint someone or a public fiduciary to act as a guardian for an incapacitated adult. And then we also have an individual, right? If you have a loved one or if you have someone in mind, then you would choose it too. And here, again, you would use judgment, common sense, and that so on and so forth. So that is guardianship. And so I'm going to just take a quick pause here as we switch gears into conservatorship. Let some of this kind of be digested here. So what a conservatorship is, it's going to take care of the financial well-being of anyone needing a guardianship, right? So think about the folks getting the guardianship is the minor or incapacitated adult who we just defined in the previous slide. And just like a guardian, a conservator can be an institution or it can be an individual. And it could include the following products: a trust, a portfolio, or simply an account. So again, this is all up to you and what resources you have and the vehicles in which you want to put them in. So here again is another definition: a guardian or a protector. So in some states they may be called protectors, is appointed by a judge to manage the financial affairs or daily life of another individual due to physical or mental limitations or old age. A person under conservatorship is the conservatee. So that's for an adult, and then of course a ward is a child. So that's what the conservatorship is the vehicle of the financial well-being of the guardianship. So there's that. When should these documents be updated? So we're almost at the end of the slide deck. I do want to say, I want to say there is one experience that I have with an adult, and I was working with this adult, and he had a child who had been diagnosed with autism. And this person was on the sort of severe autistic spectrum. And so this child was unable to care for himself. And the parents did their best to have the child at home, but ultimately it was in the child's best interest to go to a facility. And they set up a trust on behalf of that child, and they managed that trust until that child became of adult age, and that child was now 18. Now the parents were getting significantly older, and they had their own sort of affairs to take care of. And so they really enjoyed and liked and had a very successful experience with some of the places their adult child now was staying. So then they went ahead and used the legal situations and followed the proper chain of commands and such and took care of the paperwork, and they left that trust in the institution's name where their adult child was staying. And it's a trust, so that they really, they sat down, they had several conversations, they discussed it, and it gave them this sort of peace of mind to know that their son would be taken care of and that their son would have this money, and even though he wasn't able to decide what to do with the finances, that institution and that institution's legal department would be managing that trust to be able to pay for his rent and his food and his living and stuff like that. So that's a beautiful example of the benefits of a conservatorship for an individual. So then that individual became a ward of that institution pre-18, and then post-18 they would become what's called a conservatoree, the recipient of, right? Okay, so having said that example, we have here, when should these documents be updated? So when any of the named party passes on, when any party required to perform a function passes on, right? So if you've appointed an individual to carry out a will and that individual passes on, then we will then need to go and evaluate who else can we ask, and then of course we need to put that in writing, et cetera, et cetera. I also want to say, as a side note of when these documents should be updated, is let's say you do these documents and then you have that meeting and you sit down with people and you discuss what's in the documents. Should those people have questions and need clarification, I would highly suggest that you go back to your attorney or your fiduciary or your financial institution, whoever's helping you with this, and you write those clarifying sentences in there. Because again, you're not going to be there, and so when these things materialize and are carried out, you could have a room full of people that it becomes as haggard and he said, she said, right? And so, you know, when you have that conversation, if you choose to do that with those folks, if possible, who are in there, if they have clarifying questions and things of that nature, it would be a time to add that, right? And of course, we want to use judiciousness and prudence with who we discuss these informations to, and that's another decision to make, is that, you know, some of you may be thinking, well, I don't necessarily want to disclose to my children or spouse that I've decided to give them this and that or the other thing, and that's your decision to make as well. You know, you do have that relationship, that professional relationship with whatever provider it is you're going with. And so another thing to do is obviously do the research on who you go with, and that's another decision, a deeply personally relevant decision. Do I sit down and have that family conversation, or is that going to get really sticky? So that's, again, up to you. So but going back to when these documents should be updated, if there's some later additions or if there's points of clarification, right? So here, when a party required to perform a function changes their mind, so that happens too, right? These things are very important in nature, and so you may bequeath someone or you may entrust someone, and they may say, you know what, my life circumstances, et cetera, are going on. I thank you very much, and I relinquish this situation. So then, of course, you need to replace that individual or that entity. And then, of course, when you, as the author, have a significant life occurrence, such as an addition to a child in your household, a divorce, remarriage. Remarriage is also, I see, happen as well. You know, life happens, we get divorced, years go by, people change, people reconnect, reunite. Social media is doing these things where maybe if two individuals are separated, they divorce, and then they find each other on social media, and they remarry. And so that would be another time to look at some of these things. So here, change of state or residence, marriage, divorce, child becomes an emancipated adult, and then property in a testamentary trust becomes property of a surviving spouse's estate. So, you know, these are all areas of when documents should be updated. Now, where should these be kept? And again, this is up to you. These days, well, Social Security, that's still in paper. So at home in a locked box, I would advise in a waterproof, fireproof safe. You don't have to get a big, large one. You can go and get one of those smaller document safes. You can also, you know, this is, again, another personal decision. It would not replace the original Social Security card. It's a gray area. I'm gonna put it out there, and you decide what you do with it. I've had some people photocopy their Social Security card and get a lockbox with a bank. And if they have it, it doesn't replace the actual card. You absolutely never want to lose that. It's quite a process to, and there's fees associated with it being reissued. But some people, for sake of, you know, their peace of mind, again, quality of life, they'll photocopy it and get a lockbox at a bank and have photocopies in there for what that's worth. Again, that's extra for you to kind of mull over if that's something you're interested in doing. I just lost audio again. Shoot. Come on, really? Can you hear me? Hello? Can you hear me? Please type in yes. Hello? Okay, we're almost done. This is actually one of the last slides. And a lot of this is personal choice. So thank you for letting me know. Okay, so fire safe, yes, waterproof, fireproof safe. So now you have your will, which I discussed here. Here it's saying your district court. Also, some states have a registry. Some states keep it with the Secretary of State. Good. I'm hoping we didn't miss much. All I was saying was a Social Security card, get a waterproof, fireproof safe. You can get a small document safe, or so on and so forth. Okay, so with a will, again, register it. You know, whoever that executor is, you know, keep a copy for yourself. It's staying here in a locked drawer at home, not a safety deposit box. Again, document safe, you know, and put that safe in a safe place, waterproof, fireproof. So again, of course, you want to register it with your state. If it's just sitting at home, it's not an official legal document. Beneficiary forms are kept by the institution administering your insurance, your IRA, or deferred compensation. And all others should be kept in the hands of the parties named to the administer. All others should be kept in the hands of the parties named to administer them in the document, so they have it for themselves, right? So that's very clear. How are they extinguished? And that would be, this is your last slide. How are they extinguished? Your Social Security card is good for life. You only get one. You only get one number. And that can only happen, is extinguished through your passing, the death of the card holder. Advanced directives, such as your wills and your beneficiary forms, writing new ones. Anytime you write a new one, an older one has become obsolete. Care should be taken to collect the prior forms and have them destroyed, right? Again, I discussed it's sort of up to you. You know, some people may be cringing, like, what do you mean, tell who I'm putting what in that way? And some people may say, hey, that's a great idea. This could be a wonderful opportunity to have a conversation. So care, discretion, prudence, those words over and over and over again. If you create new forms, take the time, destroy the older ones. Trusts, guardians, and guardianships and conservatorships generally have court dates, court orders associated with them, and may require court action. So again, those are very specific. Follow the terms of your court, your attorney, your state. And then you have revocable trusts, are literally the only trusts that can be established or extinguished by the creator. And finally, I want to leave you with this slide. This is how you can reach your EAP. I always tell people at the end of every workshop that if you have any questions above and beyond what this hour provided, here's the phone number, right? And so we also think about if let's say we're learning a new language or we're learning a new instrument and we learned it for an hour, chances are we're not going to be fluid in it. So, you know, this is going to be recorded. And the other thing is if you need, you know, the consultations and the referrals, you can call the phone number on the upper left-hand side. You can also go to the website. And there's also, like I said, face-to-face counseling sessions that can help the emotional support around some of these things. There's child and elder care consultation and referrals. There's going to be resources for your daily life, identity theft and prevention, and also recovery service should your identity ever be thefted, right? And then there's a comprehensive website as well, and on the upper left-hand side, it's going to be anthemeap.com. And your login is Plow and Hearth. So that about wraps it up. We do have a few minutes. Any final comments or thoughts? All right, so I have a thank you so much. Thank you all very much. Thank you for being proactive about the hearing me and whatnot. I appreciate the opportunity to share. Thank you, Kenny. Again, my name is Shay, full name Shaweta Vasudeva, and have a wonderful rest of your day and afternoon.